Hi, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Should everything an attorney does or says to its client be privileged? Let's talk about that. Here's something that you probably already know, but I'm going to say it anyway, and that is that grand jury proceedings are always secret. The reason for that is because the defendant, the person who is under investigation by the grand jury, never gets a chance, in most cases, to come in and tell their side of the story. The government comes in and tells its side of the story and asks the people there to either vote for a true bill to indict the individual or to not vote for a true bill and let the individual go. The process is held in secret because that would ensure the jurors' protection as well as the protection of the name and reputation of the potential defendant. But one of the things that a grand jury has is subpoena power, and a subpoena is a document or a court order that essentially says you need to produce the following documents or you need to come and testify. Well, the attorney-client privilege is often asserted by people on documents that contain legal advice, and rightly so. Whenever a client writes to a lawyer and says, "Lawyer, I have this problem and I need legal advice on it," that letter is privileged because it is a communication to a lawyer in private requesting legal advice. When the lawyer writes back and says, "Okay, I've analyzed your problem and here is my legal advice," that too is legal advice. And it is protected by the attorney-client privilege. But what about that situation where there's more going on than that? For example, with a tax attorney. And in fact, that's what's at the heart of a case that is in front of the Supreme Court now and will be argued in January. This is how the petitioner in that case told the court what the problem was. This is the question presented: whether a communication involving both legal and non-legal advice is protected by attorney-client privilege where obtaining or providing legal advice was one of the significant purposes behind the communication. In other words, it wasn't exclusively for the purpose of providing legal advice, it was just one of those purposes. Indeed, when you have somebody who says, "What does this statute mean?" and you tell them, "That statute means this," that's legal advice. But when you ask, well, which would be better? Would it be better to apply this deduction or that deduction? Well, that better, right, means that you're asking essentially for business advice as opposed to legal advice. If you ask the question, can I legally do one or legally do the other, that's legal advice. But when you're asking for a tax attorney's expertise and advice on tax law with regard to which course is better or worse, then that can trend into the area of dual purpose advice, meaning both legal advice and practical business advice. Practical business advice is not protected by the attorney-client privilege. It just isn't. Everybody would like for it to be, I think, or many lawyers, I guess, would like for it to be, but it isn't. So here's how this whole thing came about. This company was going to do what's called expatriation. In other words, it was going to take some of its profits and move them offshore, overseas, so that they can be invested overseas. And in that process, it asked for tax advice. And it got that tax advice, but then it fell under a criminal investigation. And the grand jury requested all of the documents. Well, the law firm provided most of those documents. It provided over, I think, 20,000 pages of documents to the government. But it held back a number of documents on the basis of attorney-client privilege. And the district court was asked to compel production by the United States government. The government came in and said, "Hey, they can't hide these documents. You have to make them produce these documents." And the court essentially made a ruling that communications that provided legal advice, strictly legal advice, were to be redacted. And communications that provided business advice or strategic advice were effectively to be rendered not covered by the attorney-client privilege. So the law firm, standing on the privilege, refused to comply with the compel order, and the district court issued a contempt citation against the law firm. The law firm appealed to the Ninth Circuit Court of Appeals in San Francisco, and the Ninth Circuit said, "No joy, guys, you got to produce these documents." And as a result of that, they appealed to the United States Supreme Court for one reason, and that is because there is a split among the circuits about how to handle this. When I say a split among the circuits, the Ninth Circuit covers California, Oregon, Washington, and whatever it says about federal law on a subject in those three states, that's the law. The Ninth Circuit law is that state's or that area's law. And as a result, if you're in that location, you have to abide by that law. Well, if you're in the Fifth Circuit, which is Texas, the law may be different. And in this case, on dual purpose legal advice, it is different. And it's different in the DC Circuit. So you have different circuit courts of appeal reaching different conclusions on a unique issue of federal law, which in this case is what does the attorney-client privilege cover under the rubric of dual purpose attorney-client advice. So we have no idea at this point how the Supreme Court is going to handle the case, but I think where the government's position is fairly easy to determine from how they framed the issue when they presented their question presented. Here is what the government said. Whether the district court permissibly denied petitioner's general claim of attorney-client privilege over communications related to the preparation of a tax return that did not have obtaining legal advice as their primary purpose, while instructing that all legal advice contained in the communications be redacted. So the petitioner said, it's dual purpose advice and the court didn't protect it. And what the government says is, wait a minute now, that's not exactly what happened here. The court redacted the actual legal advice. It just didn't redact the business advice. So that's the question. Let's take a look at these two questions presented together. Now, if you look at this, it's pretty clear that the government has tried to be far more forthcoming in its presentation of the question presented than the company or the lawyer did in his question presented. So now we look at this and we think, well, how is the court going to decide? I have no idea, but let me tell you a little bit about what I think the court should decide. First of all, one of the ways in which this kind of thing raises its ugly head in civil litigation is when a civil case involves a bad product, a bad drug, other things like that. And what the client wants to do is it wants to hide documents that are relevant. And one way that you can sometimes hide documents that are relevant is by copying an attorney. And then you write on your privilege log, which you have to give to the other side, you say, I'm holding document A, and document A contains legal advice from our attorneys on this subject. The tobacco companies did this on huge numbers of documents, including the cover of the Surgeon General's report, when they refused to turn over documents in civil litigation. So the attorney-client privilege can be abused as badly as any other doctrine in the law, and frequently is abused. The privilege exists for one reason and one reason only. An attorney must be able to obtain information from his or her client confidentially, because he will rely on what the client tells him in representing the client. You don't want the client withholding information from the lawyer because he's afraid it's going to be used against him. So in that situation, you definitely want good communication between clients and lawyers. It assists in the truth-finding process when the lawyer knows all of the facts, assuming that the lawyer handles himself or herself ethically. That doesn't necessarily always happen. And as a result of that, the ruling that the petitioners want in this case, which is to be able to cloak both business advice and legal advice, is a terrible idea. It will be used to shield documents that should never be shielded. Advice that is not legal will still obtain legal protection, and some of that advice may actually be very contrary to the truth-finding process. That's what a court is all about. It's about getting to the truth. That's why attorneys cross-examine, to get to the truth. And the truth is always somewhere between what the plaintiff says and what the defendant says. Or in the case of a criminal case, what the government says on this hand and what the defendant says on this hand. The truth is somewhere in the middle in there, and you have to find it. And you can't find it if documents that should not be shielded are shielded by the attorney-client privilege. Hopefully, when the Supreme Court reaches a decision on this and releases its opinion, I'll have more of an update for you on this case. It's called In Re Grand Jury Proceedings. I'll put the little header up here so you can see. And hopefully, we'll be able to get this out when it comes out. So, again, if you have any questions, please leave them in the comments down below. You know, I think everybody says it: like, share, subscribe. I think you all know what to do. If this video is something that you found interesting and helpful, please click on that like button. And if it's something you went, who cares about that? Well, it's okay if you don't like it. It really is. It doesn't hurt my feelings. Not everything I do is going to be something that everybody will enjoy. So thank you very much for watching. As you go through your day today, you might have an opportunity to help someone. Maybe it's picking up a piece of mail that someone dropped. Maybe it's telling them to, hey, watch out, there's a car coming. Whatever it is, when you have an opportunity to help someone today, please take it. It only takes each one of us doing a little bit every day to make the world a much more wonderful place to be. Thank you, and have a great day.